Are we done here?
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury
here?
Is or
do
not.
not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your
Please do
you
not
have to
insult my
lay
intelligence.
your it's a false statement made on
Are we
oath.
done here? Are we done here? Yes,
that is not what I said.
That is what you said.
That no, I didn't. You
yes,
said
you
that.
Did. You stated
I
that.
said that circuit.
You stated that the criminal. You stated that.
I never said.
Quashante Short, QASHONTAESHORT. I'm sorry, I had to.
In the background.
I'm actually at the airport, so I had to go outside. It looks like they just departed the flight. I mean, they just arrived the flight. So I'm outside. It's a lot of people. It's a lot of people around. So I'm trying to go where there's no traffic. But thank you. That's okay. That's okay. No, I'm trying to finish this before I get finished. It's actually louder
okay. Here. I'm not sure. I read your complaint again, and you have not. I'm looking here. What is it? Intentional infliction of emotional distress?
Yes.
Is that the claim?
Yes, okay. It
is. That's not something that's really justiciable in district court.
I'm sorry. I can't hear you.
I said that.
Before we jump into the chaos you're about to witness, let me set the stage, because this isn't your ordinary courtroom dispute. No. Today's case is a masterclass in confusion, misplaced confidence, and legal terms used the way people use seasoning on TikTok cooking videos, sprinkled everywhere with no real understanding. Our plaintiff, who I'll just call Final Boss Karen, has taken it upon herself to turn a simple, awkward dinner date into a full-blown legal saga worth over $10,000. She's tossing around words like perjury, intentional infliction of emotional distress, and criminal offense as if she's starring in her own courtroom drama.
That's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court?
That's an equitable action, yes. Mm-hmm.
Okay, was that not, I thought only criminal offenses, well, I guess it would be considered, I don't know if it's criminal or however you want to consider it, but I thought only criminal offenses were brought before the circuit court. So will I have to,
what's in your head? I cannot get into what's in your head, man.
I'm sorry, I got to go back in because I can't hear you.
Mr. Jordan, let me just ask you this. Are you planning to represent yourself on this?
To be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000. I don't see how this is going to go any further. I think it's a waste of your time.
The problem is this, if you think it should be dismissed, you need to file the appropriate motion. You need to file a motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have.
Right from the jump, you can already feel the tension. The plaintiff jumps in with the classic, "Are we done here?" Which is ironic because they haven't even begun the hearing properly. This opening exchange sets the tone for everything that follows. Interruptions, misunderstandings, and a judge desperately trying to maintain order. When someone starts a hearing by repeatedly asking if it's over, it's usually a sign that they came in expecting a quick victory. But court doesn't run on vibes. It runs on procedure. And the judge immediately realizes he's dealing with someone who believes courtroom rules bend to emotion rather than law. This is where the chaos begins simmering.
As well, he stated I can't remember what he stated right now because I don't have it, the document
Perjury,
in
wait a
front of.
minute. The short,
Yes.
perjury is a criminal charge.
Okay, there were two different charges. There was one that was intentional affliction of pain, which was not. I didn't see that as being a criminal offense, but perjury, I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition and what's a crime and what isn't. If somebody gets charged with perjury, that is a criminal felony charge. You have to go through the prosecuting attorney and the police. So that's what you are alleging.
Yes, the document will show that, and I also sent forth the messages where he was lying, and it proved he was lying. I emailed that to the courts. I wasn't able to print it out, but they didn't say anything as far as me not being able to turn those documents in. But that should have been in the case file as well.
Did you put it in there?
I emailed it.
I don't see that mentioned in your complaint.
No.
If you are alleging a different count, you've got to amend your complaint to add it in. You can't. I don't know what you said you did, but you
the last time.
Complaint.
No, the last time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served. So I had to.
At this point, the plaintiff is already unraveling. She's mixing up legal terminology like she dumped a law dictionary into a blender. The judge clearly explains that emotional distress claims don't even belong in district court, but instead of absorbing the information, she treats it like a personal attack. Another classic courtroom red flag, when someone interprets legal clarification as disrespect. Meanwhile, the defendant is stuck on a phone in an airport terminal, somehow becoming the calmest person in the whole situation, despite being the one getting sued for a bad date. This contrast, her escalating intensity versus his disbelief, adds to the comedic but tragic tone of the entire exchange.
I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess after I sent the correct address and he got the document, he sent a letter that should be, I guess, in the file. He sent a letter. And
that's
then
his answer, I guess. We're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter, he lied. And then that's what brought forth the perjury. It was never perjury in the beginning. It was perjury after his response.
Well, you can't say, listen, he has the right to put whatever is in the answer.
I'm not saying he can't, but
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No.
This moment perfectly highlights how off balance the entire hearing is. The plaintiff is at an airport, constantly moving, complaining about noise, and trying to conduct a civil court matter like she's doing a quick FaceTime call. The judge is trying to keep things on track. But how do you hold a formal legal discussion when one party is dodging airport travelers between arguments? It's both hilarious and unbelievable. It also signals how little seriousness she's giving the case. Yet she's demanding $10,000. If you're going to file a lawsuit claiming emotional devastation from a date, at least don't attend a hearing in TSA traffic.
Yes, I said perjury is a lie. I know what perjury means.
Perjury is a statement, a false statement made under oath. So
exactly, and I got documents that prove he was lying.
You don't understand. It's a false statement made under oath. Under oath.
That stated a lie.
When did he testify to something that he lied about? It's a false statement made under oath.
Bottom line is you said it's a criminal offense, so I will send it to circuit court. Are we done here?
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury is a false
I know exactly what perjury means. I know what perjury means. Are we done
no,
here?
You don't.
Is it a criminal offense or not?
What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know anything.
But you're the plaintiff. Wait a minute. You are the plaintiff.
Are we done here?
You have to lay out your allegations properly.
Are we done here?
No, we're not.
Exactly what perjury means.
No, we're not.
Do not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your.
Please do not insult my intelligence.
Complaint out. You have to allege this in the complaint. You have not.
Please do not insult my intelligence.
It's not about that. You don't think. I don't think you understand what perjury is. It's a false statement made under oath.
Are we done here? Are we done here? Please do not insult my intelligence.
I said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not.
When the defendant finally speaks, you can practically hear the exhaustion through the screen. Imagine going on one date, thinking it didn't work out, and then receiving court papers demanding thousands of dollars because someone felt distressed. His stunned tone says everything. He thought this would be dismissed instantly, but instead, he's trapped watching the plaintiff argue legal concepts she clearly doesn't understand. Meanwhile, the judge is giving a masterclass in restraint. He gently guides her, corrects her claims, and tries to explain basic jurisdiction, but she counters every explanation like she's debating a Yelp review. This is where the hearing shifts from confusion to pure spectacle.
If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want intentional infliction of emotional distress.
Okay, so that's a criminal offense.
Are you going to dismiss it and refile it?
No, I'm not. No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
you can't have two cases on the ma'am. You can't have two cases going on the same issue.
Well, I'm not dismissing the case. If you want to dismiss it, that's up to you. But I, as a plaintiff, am not dismissing the case.
He has to make a proper motion.
Well, that's on him.
But I can also transfer the venue to circuit.
Yes, that's what I thought, because there were other cases that should have been transferred somewhere else. So that's okay.
Okay, I'm going to do that. Ma'am, what about his costs associated with appearing because you filed it in the wrong court?
I need to see because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be.
I didn't say that. Forward. That is not what I said.
Yes,
that is not what I said.
I said
that. No, I didn't. You said that.
You stated
I said that circuit.
You stated that the criminal. You stated that emotional infliction of emotional distress.
Here comes the biggest legal misunderstanding of the entire case: perjury. The plaintiff insists that because the defendant wrote something she disagrees with, it must be perjury. But the judge tries, over and over, to remind her that perjury only applies under oath. Writing something in a response letter isn't a crime. It's literally the legal process. But she refuses to let the point go. She's unloading accusations left and right, convinced that disagreeing with her equals committing a felony. At this point, the judge's patience is being tested on a spiritual level. He knows the case is legally empty, but he still has to wade through every incorrect claim she brings up.
Perjury is a criminal offense, but you also stated that perjury is not on the document that I placed forth before you. So criminal offense would not.
It's not in the complaint.
On there.
It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense. because that's the original offense that was placed on there.
I never
you
said
stated-
that. I
Yes,
never
you
said
did.
that.
Yes, you did.
I never said
Yes,
that.
you did.
No, I did not. Ma'am,
Yes, you did.
listen. I'm not going to sit here and go back and forth with you. I
I'm
will
not either.
repeat to you what I said.
I'm not either.
I
so
said
that's two
that
charges.
intentional-
So the charges have to.
You need to be quiet while I'm
the two charges
talking.
have
You need to be quiet.
separated.
Can you mute her, please?
Because
Mute her.
perjury is a
Can you
criminal
please
offense.
mute
It
her?
has to go to circuit court.
That will not make her hear you, Judge.
Intentional
Well,
infliction
she's
of
gotta be
emotional
muted.
distress.
What I said was intentional infliction of emotional distress is something that circuit court has jurisdiction over. I never characterized that as a criminal matter. It is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are of the mistaken belief that circuit court does not hear civil matters because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court because that's what you stated on the record. Unmuted.
She's been talking the entire time.
Well, I said I was muted.
Judge, excuse me, you don't understand how this works. Let me explain something to you about Zoom right quick.
Okay.
When I muted her and now I'm asking her to unmute, if she doesn't do something on her end, she's still muted. So right now she's still muted. But I have asked her to unmute. She's not looking at the device that she's holding.
Is there a website where I can get the forms I need for this to be dismissed?
Listen, sir, let me just explain this to you. Okay? You know, there are forms of the State Court Administrative Office website.
This section is the breaking point. The plaintiff keeps insisting the judge said things he absolutely did not say. She interrupts him, argues over definitions, and repeats her favorite line. Are we done here? As if she's the one delivering the ruling. Her confidence is unmatched, but her understanding of the law is non-existent. And the judge, still maintaining his professionalism, reminds her repeatedly that she must properly allege claims in complaint. Instead of listening, she treats every correction as an insult to her intelligence. This isn't just frustration. It's a complete communication collapse. The tension here is so thick you could cut it with a subpoena.
Okay? But, you know, if you don't know what you're doing, if you don't know what you're filling out, you know, you're just flopping around like a fish on a dock out of the water. And the same goes for Ms. Short, because she apparently doesn't understand the jurisdiction of what types of cases can be done in district court and what types of cases can be done in circuit. That's why we're having this issue right now. So, you know, look, how could I put it? If two people that have no military training, amateurs, and they want to throw hand grenades, well, you know, if you don't do it the right way, you might blow yourself up. You might blow the other person up, but you might blow yourself up too. If they don't understand how the process works, I would say this to both parties. You need to.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court. Venue is to be changed because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees in the receiving court. I don't know if you asked for a jury trial or not. You did not, it looks like. So there was no jury fee. No further proceedings shall be had after transfer until these costs or expenses are paid. If not paid within 56 days of the date of this order, this case shall be dismissed by the court to which it was transferred.
And what cost am I paying? Hold on. What cost am I paying for?
The filing fees for circuit court.
Why am I paying for filing fees for the circuit court? Because there's been multiple cases that have been brought forth.
Because you filed it in district court, we don't do intentional infliction of emotional distress cases.
Well, I need to see that in writing. I need to see that document in writing that states that
If you
you
want to
got that
appeal,
this report.
if you want to
I've
appeal,
already skimmed SCAO. I've already skimmed that. I'm reading constantly every day, and I did not see that form on there
I'm
that
sure that
states.
you are. But
Yes, I am.
if you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court. My ruling. Thank you both.
And that brings us to the end of one of the most chaotic, legally tangled, and unintentionally comedic courtroom moments ever caught on record. In the end, the judge made it clear. Emotional distress doesn't belong in district court. Perjury wasn't applicable, and the plaintiff fundamentally misunderstood how legal claims work. Despite all that, she insisted on continuing her case, even threatening to refile in circuit court. The defendant, meanwhile, walked away with nothing but confusion and probably a vow to never go on blind dates again.